Let's go to David in Clermont. David, you're on News Talk WDBO. Go ahead.
Hey, good afternoon.
Hey.
I have been married to my second wife for about 2 years. She has a 12-year-old daughter. She is the sole owner of the house we live in, and neither of us have a will. So if she kicks the bucket tomorrow without a will, what happens to the property and, of course, the custody of her 12-year-old? The 12-year-old's father lives about 100 miles away and does not have any sort of custody. So is there any way without a will that I can ensure custody and gain the property?
Well, let's start by saying this, David, that you and your wife are both perfect candidates to have a will done.
Yep.
And in your wife's will, she could certainly nominate that you be guardian for the 12-year-old if she were to pass away. So, David, if I do a will for you and your wife, we would be setting up trust and guardianship provisions, very important for your 12-year-old. Now, David, when I do a will for people, I typically do a package of 4 documents. I do the will itself. I do a living will declaration where you ask that you not be kept alive by artificial means, a durable power of attorney for health care, and a durable power of attorney for financial affairs. So all very important, David. But let's ask your specific question, that is this. Your wife owns a home you live in her name only. There is only one thing that can happen to that home upon her death, whether she has a will or whether she does not have a will. And that is this, that if she passes away, you get a life estate in it. You get to live in the home for the rest of your life. And upon your death, that home will go to her child, no matter what the age happens to be.
I see. Okay. So that answers that question. But without a will, what about the custody of the 12-year-old? Does her father even have a say-so in that regard if he does not have custody currently?
Well, the court is always going to do what is in the best interest of the child. And so the natural father is always going to have first choice to have custody of the child if mom happens to pass away. Any interested party, including you or a brother or sister, can go to court and say, Judge, natural father is an alcoholic, a drug addict,
Right.
a child abuser, doesn't own a home, not a stable parent. All those would be reasons for a court to deny custody to him, but he is always going to have first option.
Now, if the will was drafted by my wife and she does designate me as the guardian, what rights does the father have in that regard?
Well, that is when she puts in her will that she wants my husband, David, to be guardian of my 12-year-old child, she is simply stating her desire. It is simply one more factor that the court will use to determine ultimately where the 12-year-old goes to. Again, natural father is going to be first choice, but let's say the court said, you know what, natural father, not at all, not a good choice at all. Then they're going to look to your wife's will. It says, hey, I want David to be the natural father, and that's probably going to carry the most weight of anything. So David is still worthwhile doing.